Hello everyone and welcome to today's webcast. My name is Ben Frost and I'm the Public Information Officer for APA's Northern New England chapter, and I'm one of the coordinators of the Planning Webcast series. This series is brought to you by a consortium of over 40 of APA's chapters and divisions. The consortium itself is not affiliated with APA, but rather is a loose-knit association whose mission is to provide high-quality, free webinars on topics important to planners that will also help them to meet their certification maintenance requirements. Today is Friday, August 5th, 2016, and we'll hear the presentation, Planning for Religious Land Uses in an Age of Religious Diversity and Lawsuits.
Thanks for that, Ben.
I've got a couple more, Evan. For technical help during today's webcast, type your questions in the chat box found in the webcast toolbar to the right of your screen or call the 1-800 number shown here. For content-related questions related to the presentation, please type those questions in the question box, also located in the webinar toolbar on the right of your screen. We'll answer those as time allows at the end of the presentation during Q&A. Here on your screen is a list of the sponsoring chapters and divisions, and I want to thank all of them for making these webcasts possible. Today's webcast is brought to you by the Connecticut Chapter of APA. Thank you, Connecticut. And here are a few of our upcoming webcasts. We actually have a full slate for the remaining Fridays for 2016, and we've started to schedule for 2017 as well. To register for these and to see what's coming up, go to ohioplanning.org/planningwebcast. And to log your CM credits, follow these instructions. The simplest thing may be to search for the event number, which is 9105796. You can also go to Activities by Provider, type in Connecticut Chapter, and look for Planning for Religious Land Uses. Today's webcast is approved for 1.5 CM law credits for live viewing only. You can like us on Facebook on Planning Webcast Series, and we are recording today's webcast, and we'll put it on our YouTube channel. You can search on YouTube for Planning Webcast. A PDF of the PowerPoint will be available at www.ohioplanning.org/planningwebcast. And now I'd like to introduce Evan Seaman of Robinson & Cole, who will introduce the rest of his panel. Evan, take it away.
Thanks a lot, Ben. I also want to thank the Planning Webcast Series and the Connecticut Chapter of the American Planning Association for hosting this webinar today. Our panelists, aside from myself, are Daniel Dalton and Noel Starrett. I'll let them introduce themselves a little bit more when they start speaking about the different aspects of religious land use issues. I am a land use lawyer in Hartford, Connecticut with Robinson & Cole. I also serve as the Secretary-Treasurer of the Planning and Law Division of the American Planning Association. While the other guys typically represent the plaintiffs, the religious land use applicants in religious land use lawsuits, I primarily tend to represent municipalities, though I have represented religious applicants before, and I will tell you a little bit more about that when the time comes. So today's objectives for the webinar are to provide an overview of the statute that we're going to be talking about on this slide, the Religious Land Use and Institutionalized Persons Act, otherwise known as RLUIPA or RLUIPA. We also hope to let you know about the different types of claims that can arise, tips to avoid and defend claims brought under the statute, and we recognize that most of the people listening in today are probably planners, so we're going to try to provide some real case examples that we've experienced that can hopefully help you protect against claims under the statute. As Ben mentioned, you can send questions in to us. I think at any time. However, we're going to reserve some time at the end of the webinar to address any questions you might have. So please feel free to send them in along whenever you'd like. So the road to RLUIPA. In 1963, the U.S. Supreme Court had the case before it, Sherbert versus Warner. And this was one of the first cases that addressed what I would like to say call the modern balancing test for religious land use lawsuits. And the case involved a religious exercise claim that was brought by a member of the Church of the Seventh-day Adventists. And that individual, her religious beliefs required her to take Saturday off as a day of rest. When she sought unemployment compensation benefits, she was denied because under state law required that you had to be available to work any day of the week, and because she wasn't available to work on Saturdays, she was denied. There was no issue in this case that the law at issue was neutral and generally applicable, and you'll hear those terms a little bit today, so why don't I explain them now. The law was neutral because it didn't specifically target religious exercise, and it was generally applicable because it applied equally to everyone, religious affiliation notwithstanding. So even though the law at issue was neutral and generally applicable, the court engaged in a three-part balancing test to determine if this person's religious exercise was burdened. First, the court determined that this church member's religious beliefs were burdened because it forced her to choose between following the precepts of her religion and forfeiting benefits on the one hand and abandoning one of the precepts of her religion on the other hand, if she wanted to receive the unemployment compensation. The next part of the balancing analysis, once a religious burden is established, is to determine whether the government entity can justify its actions through a compelling interest. Here, there was no compelling interest, so the plaintiff, the religious church member, won. Normally, if there was a compelling interest, the court would move on to a further step in the analysis to determine whether the law was narrowly tailored to advance the compelling interest. However, it didn't reach that situation here because there was no compelling interest. Decades later, in Employment Division versus Smith, this was an opinion by Justice Scalia. Basically, Justice Scalia undid decades worth of Supreme Court free exercise law. And whereas in Schubert v. Werner, a law that was deemed neutral and generally applicable could be deemed to burden religious exercise, Justice Scalia said, no, that's not right. If there's a law that's neutral and generally applicable, it can't burden religious exercise because its effects are only incidental to religion. If this were still the law today, that would be great for planners and municipalities out there because it would be difficult for a religious plaintiff to establish a violation by a government entity. In the facts of the case, they involved a member of the Native American Church who also sought unemployment compensation, but was denied compensation after he was fired for ingesting peyote in accordance with his religious beliefs. Ironically, this Native American Church member who ingested peyote was employed as a drug counselor. And rather than pursuing the three-part burden-shifting test that the Supreme Court had previously set forth, Justice Scalia said, no liability because the law is neutral and generally applicable. The next case, Church of the Lukumi, occurred a couple years later, and in that case, the Supreme Court limited Justice Scalia's decision to some extent insofar as the Smith decision shouldn't be read to permit the targeting of religious practices under the guise of a supposedly general and religiously neutral ordinance. In that case, members of the Santeria Church sought to lease a property in the city of Hialeah, and one of their religious practices was animal sacrifice. Perhaps understandably, perhaps not, some members of the community became fearful of the animal sacrifice that was going to accompany the religious beliefs of this group. So they petitioned and complained to government officials, and through a series of hearings, the city passed ordinances that restricted and prohibited the animal sacrifice so that the Church of the Lukumi couldn't follow its religious beliefs. In this case, as opposed to the other two cases I just discussed, the law was found to be not neutral and not generally applicable. It was not neutral because the whole impetus for its enactment was to target religious exercise, namely to prevent the Church of the Lukumi from carrying out animal sacrifice. Also, it wasn't generally applicable because the law, while it was supposedly enacted to prevent cruelty to animals, didn't prohibit other types of activity that were allowed that also arguably were cruel to animals, such as hunting and those sorts of things. So here the court said that the ordinances at issue were illegal. And this was all well and good for religious advocates and groups who, after the Employment Division versus Smith case, complained, and perhaps rightly so, that the law should be developed to give them certain protections. And while Lukumi did kind of sway back and give them certain protections, it wasn't enough for them. So the Religious Freedom and Restoration Act was passed in 1993, and this act, also known as RFRA, it lasted for only about 4 years, as you'll see in the case listed right below it, City of Bernie versus Flores, rules that RFRA was unconstitutional and as applied to the states. RFRA still remains good law today, and you'll probably recognize it from hearing about such cases as Hobby Lobby, the Obamacare case that involves the contraceptive mandate issue. So while RFRA is unconstitutional as applied to the states today, several states have gone forward and enacted their own state versions of the Religious Freedom Restoration Act, and they're known as mini RFRAs. I believe there are about 20 or 21 states right now that have mini RFRAs. So those claims are often brought along with claims under the Religious Land Use and Institutionalized Persons Act, which you'll see was enacted in 2000. And a couple points to stress about the statute are it's a very young statute. It's only approximately 16 years old, and as compared to other types of discrimination laws that are more developed, this statute, the case law under the several jurisdictions, is still developing and is very unclear. So while we're going to try to provide some useful tips today, many areas remain murky and are admittedly difficult to prepare for. Adding to some of this confusion is that different courts throughout the country have interpreted and applied the statute in different ways. And we're going to get into that a little bit later on with some war stories of our own and also some cases that we haven't been involved with but have been following. And lastly, the Supreme Court has never considered the statute in the land use context. It has considered the statute in some prisoner rights cases, which one of which I'll talk about later, but it hasn't in the land use context. And the last, relatedly, the statute applies in only two contexts, land use and incarcerated persons. So the incarcerated persons provision, which we're not going to really get into too much today, but a little bit, those claims are brought by prisoners who are trying to exercise their religion in a certain way, whether they want kosher meals or certain time to pray and whatnot. The next slide shows the types of RLUIPA claims that can be brought. And I'm just going to read through these quickly because we're going to be discussing them in a little bit more depth throughout this presentation. So the first claim, and this is the most common claim that's brought, is under the substantial burden provision. The second claim is known as an equal terms provision claim. And that's probably, it might be the second most frequent of all claims brought, maybe just as much as substantial burden. It's close. The last two provisions, though, the claims under those statutes are not as frequent, and there is not as much case law under those provisions. And the first is the non-discrimination provision, and the next is the exclusions and limits provision. With that, I'm going to hand it over to Noel, who's going to be discussing a very important question: what is religious exercise?
Great, thank you, Evan. Thank you for all the work you put into this. My name is Noel Sterrett. I'm an attorney at Mauck & Baker in Chicago. We handle religious land use cases on behalf of various religious groups and ministries and various things across the country. And so we're usually on the plaintiff side. So I'm usually the one called from a church or a mosque, and they say we've been denied, or this is what the zoning code says, so where do I go? And then I'm the one tasked with looking at your codes, trying to figure out how the municipality treats religious exercise, religious assembly uses, ministries, and figuring out if you guys did it right or wrong. And so I first of all want to thank everybody that's attending today, because that's a good sign that you guys are putting forward the time to try to understand these issues. Unfortunately, many municipalities still, 16 years after the passage of the Religious Land Use Act, have no idea that the law exists, and as a result leave their municipalities subject to a lot of exposure and create a lot of problems that could otherwise be avoided. So as to this slide, religious exercise under the Act is to be read broadly, and that means that it's any exercise of religion, whether or not compelled or central to a system of religious belief. That's there because they want to make sure that they protect all sorts of religious exercise, not just whether or not, for instance, the Catholics can take the Eucharist, which is central to the faith, or whether or not it's you know, another, perhaps an exercise of religion that's not so central to the faith, but nevertheless they consider to be part of their religion or part of their worship. And so the Act then goes further and says, because this issue had kind of been dealt with differently in the courts, whether or not the actual use or building or conversion of real property, it constitutes a religious exercise. And the Act just solves that and says, yes, yes it is. The acquiring, use of a building, conversion of it for religious exercise, we're going to say that that should be protected under this Act. And so you can't just say, well, there's nothing religious about building a building or where you're locating or converting your property. Where in the Bible does it say that, or where does it say that in your Quran? And so this statute and this provision just says, no, this isn't going to be a debated issue, this is protected. And so next slide, Evan, would be great. One of the things that under our constitutional government that we have, limited government is not supposed to be weighing in and saying what is and what is not sufficiently religious. That violates the Establishment Clause, and courts up and down, the Supreme Court have long said it's not for the government to be able to tell some religious person how religious they are or whether or not they're you know, acting in accord with their religious faith. However, the courts have said that for religious beliefs to be protected, they must be sincerely held. And what that means is you can't find Jesus, so to speak, simply because you were denied some type of relief from the government. Some people find or try to couch or characterize their activity after the fact in religious terms. And so you can see that they're being insincere in their claim to whatever they're doing being a religious exercise, because they usually find faith or religion after they were denied what they want to be, you know, doing, which typically doesn't come up in religious land use cases, because more often than not you're going to be dealing with established religious groups, be they unfamiliar ones or new ones. You're usually going to be dealing with a church, a mosque, a synagogue, a Sikh temple. Those are the types of things that you're going to be dealing with. So these questions of whether or not the beliefs are sincerely held or whether or not they're sufficiently religious typically don't come up. However, you're also going to be taking a look at what other types of activities could be religious, and there's going to be a slide that we're going to talk to about that as well, which, Evan, in the next slide, the courts have found that homeless shelters, soup kitchens, and other social services, these are religious uses. Just because it's not a place of worship doesn't mean it's not religious. So if you've got a crisis pregnancy center, a homeless shelter, soup kitchen, these are ways in which the faith community goes out and tries to minister or serve the community. And so they're compelled by the religious beliefs or commitments of the faith community Religious gathering in homes, these are the types of lists that you need to be aware of because if you get an application or you're trying to plan for these types of uses, you have to pay particular attention to how you're treating them because the religious component of this use is going to give them greater protections simply because we have the First Amendment and we also have the religious land use law that says that we need to protect these religious groups and from the discrimination that sometimes comes when you have a municipal board, for instance, that's looking at whether or not they're going to approve a mosque or a community center, and they're saying, well, maybe we can just deny them and under some general neutrally applicable way. So those are examples of religious uses, and then obviously with the next slide, you can also talk about what are not cases. There are cases where the courts have found these are not religious exercise. So when one court in the Church of Universal Love and Music found that basically they just adopted this religious belief to circumvent the zoning. They were never religious beforehand, but all of a sudden they've made a church out of what they want to do. The other case was the Westchester Day School case, which basically said there's no religious purpose to you building the gymnasium. You were just going to have sporting activities there, and so this isn't religious exercise. So those are the slides that I wanted to cover, and Evan, take it from here.
Actually, this is Dan. This is Dan Dalton. I'm with the firm of Dalton and Tomich in Detroit, and I'm the old guy in the pictures. Been litigating these cases the last 14 years on behalf of religious institutions, and 10 years before that I was doing insurance defense for municipalities. So I've had the opportunity to be on both sides of this issue and have a good understanding in terms of what the concerns of cities are as well as those of religious uses. So the question of what is a land use regulation, that comes up quite frequently in terms of whether or not RLUIPA applies to a case. Fortunately, Congress defined the term land use regulation, and it's on your screen right now. A zoning or landmarking law or the application of such a law. So we know what a zoning law is. A landmarking law, that's not truly defined, but a lot of times if you look at like in the congressional record, you'll see that a lot of that was referencing historical designations. So where a city would put a historical designation on a building, for example, that's kind of, I think, what they were talking about with landmarking. Or the application of such a law, that's another question in terms of, well, what does that really mean? Does it mean building codes? Does it mean deed restrictions? Does it mean eminent domain? It kind of left that open, and for us representing religious uses, we've kind of tried to stretch that as much as we can, and for those on representing municipalities or communities, have tried to restrict it as well. So you have the two parts, the zoning or landmarking law, and then the second part goes to ownership. The person asserting a RLUIPA claim has to have an ownership, a leasehold, easement, servitude, or other property interest in the land, or a contract or option to acquire such an interest. So therefore, what that means, or when you're looking at that particular issue, is does RLUIPA apply? Do you have a zoning type law, and does the person asserting the claim have an ownership interest? When RLUIPA was first enacted, that ownership interest was dealt with quite a bit in the context of a property owner who leased a space to a church or mosque or temple, and they were zoned out of the property, and then the property owner tried to assert a RLUIPA claim, and the courts have found, no, you're not the one that's looking for this particular use. That's the church or the temple or the mosque, so we're not going to allow your claim to exist. So when you're looking at the applicant as a planner, whether you're representing a religious use or not, the question is what are we looking at in terms of the laws that apply here, and also does this person have some sort of interest in the land? So the next slide, please. So again, looking at what a land use regulation is, eminent domain. Courts are really at two different spots on this particular issue, and I'm actually litigating a case in New Jersey right now on this particular point. There was a case called Cottonwood Christian Center versus Cypress Redevelopment Authority, which was out of the Ninth Circuit. Actually, it was a district court decision out of the Ninth Circuit that first addressed this issue back in 2002. In Cottonwood, what happened was a fairly large church wanted to buy a piece of property in a particular area of town, and the Economic Development Corporation didn't want them to be there. And really what they wanted was a Costco, and they put that right out there in their planning notes. Cottonwood went ahead to purchase the land. The request for a under CEQA and under the California laws for zoning approval, a conditional use permit was denied, and then the Economic Development Authority went ahead and used eminent domain to purchase the land to keep them out. And in that case, the court didn't squarely address the issue of the use of eminent domain fell within the context of a zoning or land use regulation. But what the court did is said, you can't do this, and this is wrong, and these are the reasons why it's wrong, and therefore, concluded at the end of the day to grant an injunction for the church, to be there. In St. John's United Church of Christ versus City of Chicago, this involved an expansion of the airport at O'Hare Airport. It involved a cemetery part of the property. And in that area, the Seventh Circuit decided that we're not going to allow eminent domain, which is not part of RLUIPA. It's not a zoning or landmarking law or other portion or the effect of those laws. So it kind of depends where you're at. We've got a split in circuits with the Second Circuit with this congregation ad asierum, and the St. John's United Church in the Seventh Circuit on what it is or isn't. If this ever gets to the Supreme Court, I think they'll resolve the matter. The Supreme Court's kind of interesting on RLUIPA claims on the land use side. There's been plenty of times that you've had RLUIPA claims going up on the land use side to the Supreme Court, but the court just hasn't taken one yet. Whether it's defining substantial burden or eminent domain, what falls within a land use regulation or whatever the case may be, but the court hasn't really addressed that issue yet. What is a land use regulation? Environmental review, possibly. In New York and in California and on the West Coast, a lot of state laws have environmental laws. In New York, it's called SEQURA, or it's SEQURA, which is the State Environmental Quality Review Act. And in California, it's the California Environmental Quality Act, or CEQA, and a couple of other states have similar ones on the coast. In those cases, the local municipality used those environmental regulations to preclude a religious use from being built or being put in an area. In other words, they kind of used the law to force them out. And in those cases, the courts have said, wait a minute, you can't use this law improperly like the way you've done and force you out. Having said that, though, courts pretty much have said universally, when you're a religious use, you still do have to follow through the process. So there's a case in the Ninth Circuit, for example, called Gute versus San Diego County, where a church was, in existence for many, many years, and the county figured out that they didn't have a conditional use permit or didn't have approval, so they required this church to go through a conditional use process, and the church didn't do it. They filed suit. The court said, well, yeah, you're going to have to comply. You are going to have to go through this environmental review, even if you've been told you're going to be denied or if you think you're going to be denied. You have a futility argument you can make, but you still have to go through that issue. But if it's used improperly, you have that will fall within a land use regulation claim. What's interesting and what has not been litigated yet is whether the cost of going through these environmental claims rises to be a substantial burden or falls under RLUIPA. In Goutte, they raised that in a footnote. And you know, in some of these states where you have it, for example, I had one in the city of San Diego. It cost $250,000 just to go through the environmental review to get denied, and it was 18 months. And you just can't develop land that way. It's just too expensive and too unpredictable. So I think that'll be an interesting issue going forward. Building codes may or may not be land use regulations. There's this Salmon case out of Phoenix where the court clearly said it was not. I've had cases where here where the local municipality has used the building code to keep a occupant out, Lighthouse Community Church versus City of Southfield, and the court said that the application was in fact a land use regulation. So it really depends again where you're at and what particularly the issue is in terms of land use regulations. Next slide. A new one, deed restrictions. We just had a case out of the Northern District of West Virginia. And fun fact, there are 6 federal courts in West Virginia, believe it or not. And there's a Northern District and a Southern District. And in this particular area, the city of Elkins had a economic development corporation that deed restricted the land and specifically allowed theaters and all sorts of secular assembly uses, but didn't allow churches. And the theater actually was on property and wanted to sell to a church, and the church would use the property and be the owner, but the theater would have it, you know, and continue on. But the economic authority said no, you couldn't do that. So we filed a declaratory action, and the court found that deed restrictions are land use regulations for purposes of RLUIPA, and under an equal terms analysis found that the implementation of the deed restriction violated RLUIPA. In Alabama, there was just a case that came out within the last 2 months where a federal court concluded that a state law restricting the housing of registered sex offenders was a land use regulation. And there was an interesting factual scenario, and which probably occurs more often than we realize, but particular community, a church had housing for sex offenders on its property. Because quite frankly, under most state laws, you have to have the law requires you can't have a sex offender within 1,000 foot of a school, a church, or whatever the case may be. And the way, so there's really no place for these folks to go. They can't go home. They can't go. No family's going to take them, and you know they're just kind of in a catch-22. And so this church actually put mobile homes and housing on their property. Community didn't like it. They went to their state senator. A law was passed that said you can't have housing within a certain district of a church, and the federal court invalidated that, finding that state law restricting the housing of sex offenders was in fact a land use regulation. So I guess the bottom line for this story or these sets of slides is when you're analyzing a land use application, the first thing is what laws are you applying, and depending on what circuit you're in, you have to make sure that falls within the parameters of a land use regulation. And then the second thing is, does the person asserting the land use claim have a property interest, whether they have a lease, an option to buy, something under state law will tell you whether it's a property interest or not, a contract or whatever the case may be. Back to you, Noel.
Yeah, so we're going to talk now about ripeness. So that's a good picture, the strawberry in the bottom. So one of the things that Congress wanted to tell everybody in passing the religious land use law is just by adopting this law, that doesn't mean that religious groups don't have to go through processes. In other words, they don't have to go through the process of allowing the municipality to give them an up or down. And one of the particular concerns that the courts have is, for instance, if you go through or if you decide not to go through the process, like I think it's Goutte or Guaitai case that Dan was referencing, they never went through the process, and so they never were able to say that the municipality had been given a shot at approving them and allowing them to go forward. Well, the courts routinely try to say to the religious applicant, well, show me that you went through and that you've gone through the process, and we need to see a final decision from the municipality, and to make sure that we know that all the facts are there, because the court doesn't want to look at this unless the municipality's looked at it first, and so that you can make a case as a religious group that, look, all these facts were considered, and nevertheless they denied it, or they denied our use or our addition, application, or whatever it is that they have before the board. And so this is the ripeness case. The courts are going to not want to take these cases and will dismiss them or stay the case, in one case that I'm involved in, if they have any indication that they want to develop the factual record first before the municipality, before they can render a decision. Sometimes this is a court's way of assessing whether or not the municipality has really dug in their heels, and if the municipality is going to be acting in good faith. Sometimes the municipality takes a line in the sand and says, well, even if you apply, we're not going to give you a good faith hearing, we're just going to deny you. You know, your application is dead on arrival. In which case, you know, the church can make a case to the court, the church or a religious group can make a case to the court and says, look, it would be futile for us to go to the board. They've already told us that they're going to deny us. But courts are generally reluctant to take a case or a rule on the merits of a religious land use claim unless they just determine that the case is ripe for review. There's an immediate injury exception to that the religious groups can you know, avail themselves of, and there's a lot of difficult case law to wrestle with in this area, simply because what we're dealing with is a First Amendment protected activity, and in many cases these religious groups are being burdened and being affected by a city's citation, a notice of violation, or a you know, hostile municipality which may come right out and say, we're not going to allow you to continue at this property. So there's this impairment of their free exercise. There's a cloud of uncertainty that's cast on their use. And so you have to make the case as a plaintiff's attorney that, look, there's an immediate injury here. We're losing members. They've stopped our ministry to the community, our service to the community. And so that's one area that we're going to see developing more and more, is how the courts are going to wrestle with the land use side of this, which typically, you know, courts are familiar with takings cases, eminent domain cases, and then the First Amendment side, which is a far lower burden, because when you show that this is putting a chilling effect on your religious exercise, in the First Amendment context, that's usually sufficient. Evan, you want to turn to the next one? I think I'm covering the substantial burden provision as well. One of the key provisions, if not the most important provision and the most often litigated, is the substantial burden provision, which applies in several areas. When you are zoning or planning for religious uses, if you're going to have a case-by-case way of dealing with uses, or a new use that comes into the community, that's going to subject you to the substantial burden provision. Because one of the things Congress realized, both in the land use context and in the institutionalized persons context, is these individual processes, so a special use hearing, a variance hearing, where you're looking at the specific facts for specific use to give a specific applicant a remedy or relief, a variance, a use permit. That is the context in which Congress saw ample evidence that that's where the discrimination can occur in the background, because you're no longer applying things generally. You're looking at things, you know, in great detail with respect to a specific applicant. And so when you have these systems of individualized assessments, that's going to be the jurisdictional hook where this is going to make you subject to the substantial burden provision. The other ones are federal funding and use of, you know, whether or not the municipality receives federal funding, or whether or not the removal of the substantial burden affects interstate commerce. For example, if a mosque wants to build in a place and the municipality is saying no or has denied them a special use permit, well, that affects the commerce, because all of a sudden you're talking about the contractors they've hired, all the other business activities that go on when you build these things. And so those are the jurisdictional hooks of the substantial burden provision. Now, you're asking yourself what many courts and what many religious groups are asking yourselves, well, what is a substantial burden? Well, it's not defined in the law. And unfortunately, because it's not defined in the law, that has led to a lot of uncertainty. And the courts are all over the map as to what is a substantial burden or not. Obviously, from the religious groups, they see the burdens imposed by land use regulations or denials as substantial, almost always, because it's impairing their ability to exercise their religion in the way they feel called to. And however, following the adoption of the religious land use law, a number of courts went out and tried to bring a definition, but really they didn't define it. What they did is they found basically in the thesaurus a word to substitute in for substantial and a word to substitute in for burden. But that left the parties, the municipalities and the claimants still wrestling with what a substantial burden is. And so the Act does say that substantial burden should be interpreted broadly, but not any broader than the Supreme Court's cases previously. That doesn't give you too much help, but you can then go look back at the Supreme Court's jurisprudence before 2000. But again, these are things that are difficult to assess. Here are some examples of what a substantial burden is or have been found to be. Complete or partial denials of applications for zoning relief. If the result of what you're doing is going to be the end of a religious use, for example, a mosque moves into town and they want to, they're new to the community, they want to locate, you know, here where you've designated them as special uses and you deny them that special use, then all of a sudden you're going to have questions as to whether or not is this a substantial burden on their religious exercise. Sometimes religious groups can show, well, this is where all of our members live, you've listed us as a special use, you've denied us, we cannot operate, therefore it's a substantial burden on our religious exercise. Conditions upon approval. If these conditions are so onerous that you're basically limiting their use, that's going to be another question. Cease and desist orders. I just saw one of these in Texas a month ago. You know, they found a small Hispanic Pentecostal church meeting, and they said, nope, you've got to stop your meeting, and here's your cease and desist order with a $1,500 fine each day that you remain. That's going to create a substantial burden claim in all likelihood. And then the text of zoning regulations, which may be so onerous as to create a substantial burden because you've placed such a burden on them, or you've either given them no place to go or for various other reasons. But let's move on because I'd really like to turn it to Dan and Evan as well. And as you can see, go ahead back to that last map. As you can see, these are the circuits in the federal districts, and all the circuits have dealt with substantial burden slightly differently. Some have, you know, cited the other ones, but depending on where you're at, you're going to have, you know, your city council or attorney is going to have to look specifically at the substantial burden standard in your circuit. Okay, next slide, please. Here are a couple of things. A substantial burden that you need to know. A substantial burden may occur with the application of neutral and generally applicable regulations. Well, that's the whole purpose of the religious land use law. When the Supreme Court changed the First Amendment jurisprudence and said neutral and generally applicable laws usually don't lead to a substantial burden because they apply to everybody, the reaction by Congress was saying no, because that gives ample ground for religious exercise to still be infringed, because now our government officials will just adopt neutral and generally applicable laws, but nevertheless that could still put the religious groups in harm's way. And so don't think that just because we have a neutral and generally applicable zoning law that gets you out of the religious land use law, because that's the whole purpose of the religious land use law. The substantial burden is a regulation that renders religious exercise effectively impracticable. This was a Seventh Circuit case, and this case actually, in my opinion, has since been undone in terms of its holding in the Seventh Circuit. later Seventh Circuit case has cited to the prisoner rights case in the Holt versus Schlemm, the Supreme Court decision, and cited in the context of discussing this club case, said this standard is too hard. It's too high of a standard. The Supreme Court is clearly indicating to us that the standard for what a substantial burden is on religious exercise should be much lower and easier to satisfy for the religious person or group. And so effectively impracticable was a very high standard for the religious applicant to meet, and the club case was actually a case that my partner litigated in 2003. The Midrash Sephardi case, which basically says, well, if what you're doing by way of land use regulation, either in what you're enacting or imposing on the group, coerces them to forego religious precepts or mandates certain conduct. So you're making them walk farther, or you're saying that they can't meet, well, that's going to be a substantial burden. Or if that also implicates how much you're restricting their growth. If you're going to deny them the ability to install a parking lot or put on an addition, well, then you're going to have to talk about the substantial burden that is on their congregation. So that may subject you to liability there. And imposing unjustified delay, uncertainty, and expense. If the religious applicant comes in and the municipality starts playing games with them, where they're delaying the hearings, they're moving things around, they're playing hide the ball, and this is creating a substantial amount of uncertainty, expense, delay. It's unjustifiable, or you're forcing them, basically in a position where the uncertainty is leading them to having to find another place. Well, that's the type of substantial burden that the Seventh Circuit at least has found, and I know other circuits have stated it's Constantine case. Also, in the Petra case and Vision case, two other cases on the Seventh Circuit, the denial of an approval is not a substantial burden where there may be when there's no reasonable expectation of approval. When a land use, a religious group moves in and they had no expectation, and the expectation was not reasonable at all, that they were going to get zoning approval. Well, the Seventh Circuit says, well, that's not a substantial burden. Some courts have looked at whether other sites are available. A lot of municipalities will say, well, now that you've bought this property and we're not letting you use this, you have to show to the satisfaction of the court that there are no other sites available. Next slide, please.
Hey, Noel, this is Evan. I just wanted to jump in here and because I see that the Second Circuit case is cited here, and Connecticut's in the Second Circuit, and I wanted to quickly talk about that one and just provide a real case example that's kind of based off that case. So you've been talking for a while. Why don't you go grab a sip of a Gatorade or something and get your wind again?
Great.
So the Westchester Day School case, in that case, a Jewish, Orthodox Jewish school wanted to renovate its educational campus because they claimed that the buildings were run down and not big enough to accommodate the religious beliefs. So they applied for a special use permit, which was ultimately denied, and they sued under RLUIPA. The court said that looked at a couple factors. First, whether the decision to deny the application was arbitrary and capricious. And the court said, yeah, it was arbitrary and capricious because there was a group of neighbors with certain political connections who came in and raised the typical not in my backyard concerns, which there was not evidence in the record to support. The second, and I think just as important, or maybe slightly more important, factor was that the court considered whether the denial left the school with other options. Would the denial force the school to continue to teach its Jewish students in the facility that wasn't adequate to accommodate their religious beliefs? Or was there somewhere else that they could go? Or was there something that they could do to their campus, rearrange classrooms or anything like that to allow them to better exercise their religious beliefs? And the Jewish school hired real estate experts and planners to testify at trial to say that there were no other options available. This was the only option. They had to renovate the building in this way. And the court was persuaded by that, and it found that there was a violation of the statute. I mentioned I wanted to give a brief story of a case that I was involved with, and it's the only case where I have represented the religious applicant as opposed to the municipality. And it was in Connecticut, and it was a lawsuit against my hometown of Norwich. And in that case, we represented a Catholic church and a soup kitchen. The soup kitchen was located downtown, as was the church, not on the same campus. The soup kitchen was probably about a third of a mile away from the church, and it had been operating in a building for maybe 20 or 30 years, feeding hundreds of people daily. Also had a food pantry in sight where people could come in and bring food back to their homes. In about the summer of 2013, there were serious issues with the building that the soup kitchen had been leasing, and its landlord informed it that it had to get out for renovations to move ahead. Otherwise, the roof could collapse, and that would just be very problematic and terrible if any of the patrons were caught in that mess. So, with little time and few options, the soup kitchen said, hey, we have this former parochial school right next to our church, about a third of a mile away, that has since been closed down. So why don't we go there and operate our soup kitchen from there? So the city of Norwich said, yeah, that sounds like a good idea. We'll give you a 6-month temporary permit to do so. After 6 months, if you want to stay there, you have to apply for a special permit to stay there permanently. So the soup kitchen moved in there, right across from the church in a residential neighborhood, and the residents didn't like it. They complained about all sorts of bad behavior, trespassing, littering, etc. Anything that you can imagine, and maybe a little worse. So during that 6-month period, the soup kitchen was searching around the city for alternate locations that it could go. It searched probably a dozen or more locations, but for one reason or the other, they were either too expensive, there were too many problems with the property, environmental concerns that would require remediation, or the properties were too far from the downtown area. And this was an important fact because the population served by the soup kitchen, most of the patrons didn't have access to cars or even public transportation, so it really had to be within a limited radius for the soup kitchen to serve these people. So with nowhere else to go, they applied for a special permit to stay at the property permanently. Hundreds of people packed the special permit hearings, one side of the room filled with supporters of the church, the other side of the room filled with opponents. Stories of bad behavior all throughout. We raised religious freedom and RLUIPA, the First Amendment to the U.S. Constitution, and ultimately the Planning and Zoning Commission denied the application a week before Christmas, December 18th. The same evening, they approved an application, a special permit application to a property owner to sell guns downtown. And the reason this is important is because I'm sure many of you have heard of the tragedy at Newtown, the elementary school, where many children lost their lives. And this was approximately 4 days after that. So 4 days after that, you have the Planning and Zoning Commission rejecting a special permit for a soup kitchen to help poor people and approving an application to sell guns. So we filed a lawsuit in federal court alleging substantial burden and all types of other claims that you're going to hear later on. And the substantial burden claim was premised on this exact ground noted in the Westchester Day School case, that there were no alternate sites available for the soup kitchen to locate. And if the denial were to stand, the soup kitchen, which was a ministry of the church, would have to terminate its operations altogether. So this religious exercise, as Noel was discussing earlier, whether a religious exercise is terminated or just inconvenienced in some way, here it would be completely terminated. There were a couple other related lawsuits that arose. The city issued notices of violation, another federal lawsuit. Then the court required the church and the soup kitchen to seek a use variance application to establish ripeness, which Noel mentioned a little bit earlier. And I'm not going to get in too much to that other than to note that when you are considering, agency officials or planners are considering applications from religious institutions, be prepared for unordinary zoning considerations to come into play. For instance, in considering a variance, at least in Connecticut, typically you don't consider whether there's another property available for the applicant to do whatever he or she's seeking to do, or you don't consider the financial resources of the applicant. Under RLUIPA, the substantial burden provision, that does come into play, because if the religious group doesn't have money to afford another location, or if there is no other location, then that weighs in favor of finding a substantial burden. And to conclude this real case example, just earlier this year, a settlement was reached with the city, working with its lawyers, to come together and find common ground to allow the soup kitchen to continue to operate. And I'm proud to say that the soup kitchen is up and running today and wasn't closed at all during litigation, feeding hundreds of people who really needed it. Dan and Noel, feel free to jump in with any other stories. I know that there are a couple more slides under substantial burden, but I thought I would just provide that example.
And that's really the reason why Noel is, Noel and I allow Evan to speak at these things, because now he's part of the whole religious land use good side. So, right. So good for you. I've had a couple. I've had cases where zoning officials have said, you can own the building, but you can't occupy it because we don't believe that you have a sufficient parking, and using parking as an excuse. And the courts have invalidated that, finding that to be a substantial burden. I've had cases where a campus, for example, in California, a high school campus was not permitted to renovate their existing buildings based on CEQA and historical designation concerns, and courts have found that to be a substantial burden. Cases where the city had made comments that the church doesn't really need to be there. I had a church that left the Episcopal denomination and became an Anglican church, and the group of the city council and the planning commissioners were Episcopalians, and they were not happy with the group that left, so they denied the land use, and for their own reason that they thought that the church didn't need a spot in the community. So all of these kind of cases, I guess it's just that, that like what Evan was saying, it really goes to the heart of your analysis when you're doing your site plan reviews of, does it comply with zoning or not? And if it does, if you start making up excuses, to deny them, when site plan approval should be granted, you're going to find yourself at the heart of a RLUIPA case.
Yeah, and I think one thing that you need to know in these cases, too, is courts are often looking for the bad actor. So if they see something that's fishy, particularly when the Plan Commission goes and approves it and recommends approve, but then the City Council, for whatever reason, completely goes against the Plan Commission, or they see gaps in time, delayed hearings, ways in which you may be treating the religious applicant different than you would a commercial business or other groups, that's when the courts are going to be taking particular note and will be more inclined to find a substantial burden when they can find the bad actor or actors, so to speak. But other than that, for the sake of time, Evan, we probably want to just move on to the compelling interest test, because once the church, mosque, religious group proves that they've been substantially burdened, then it's going to be the municipality's burden.
And that brings me to the next slide, compelling interest. So once a substantial burden is established, the burden then shifts, the burden of proof shifts to the municipality to come forward with what's called a compelling interest to justify its actions. Not only does the interest have to be compelling, but it also has to be advanced in what are called the least restrictive means possible. I'm going to first focus for a minute or two on the compelling interest aspect. The U.S. Supreme Court tells us that compelling interests are interests of the highest order. You can't merely speculate that something bad is going to happen, such as traffic concerns or total chaos for the zoning scheme in general. You have to have specific evidence that, in the case of an existing religious institution, that harm has already occurred, or for proposed institution, that it is very likely to occur. Retaining experts, planners, environmental consultants, traffic consultants is very important here to really sit down and analyze the possible harm that may occur. The compelling interest standard, it is very difficult to satisfy, and municipalities do not want to find themselves having to do so. It's even more onerous than intermediate scrutiny, which is found in some other First Amendment contexts, and very much more onerous than the rational basis standard, where the government has to, which is very easy for the government to satisfy, because it has to only show that there's a rational basis in its treatment to further some government purpose. Some examples of compelling interests. One court in the Seventh Circuit has found that preserving the rural and rustic single-family residential character of a zone is a compelling interest. There are cases that come out the other way, where preserving the zoning scheme is not a compelling interest. And the more that you think about it, it kind of makes sense that it should not be a compelling interest, because saying that a denial of a religious institution's application is in furtherance of a zoning plan could be asserted at any time. It could always be used as a compelling interest. So I think what planners and city attorneys and agency officials should consider is specific aspects of the zone in which they're located that could be affected by the proposed development. Preventing crime and ensuring safety of residential neighborhoods, that's a compelling interest. Crime and safety usually arises in a situation where there are soup kitchens, food pantries, developments that have people in need of services coming into neighborhoods seeking those services. The Second Circuit has said traffic could be a compelling interest. It's not clear. It's still an issue up for debate. Now, the least restrictive means, this is even less clear than what is a compelling interest. The least restrictive means basically says that for the government's compelling interests to justify the substantial burden on religious exercise, there can be no other alternatives available to the government that would impose less of a burden on the religious group. For example, we have this image from a Supreme Court case that is known as Holt versus Hobbs, and it's a prisoner rights case, one of the few prisoner rights cases that we're going to discuss today. And in that case, the prison had a policy where it prohibited any facial hair other than short mustaches. And a Muslim inmate said that he wanted a beard because his religion required it. He said he wanted a beard about a ½ inch in length, and the prison said no. And in saying no, the prison said it had two compelling interests. First, the prison argued that the Muslim inmate could hide contraband or weapons in his ½ inch beard. And second, the prison said that preventing inmates from growing beards was necessary because otherwise they could change their appearance by shaving, and that would make it more difficult for prison officials to keep an eye on them. The Supreme Court said, there is a burden on a religion here. He can't have his beard. Even if there is a compelling interest, it's not been advanced in the least restrictive means possible. And the reason the court reached this conclusion is because while it's prohibited the inmate from having a beard, inmates entirely from having beards, it didn't require heads to be shaved. It allowed a mustache. And there was also an exception for prisoners to have beards if they had certain skin conditions. So it wasn't a complete prohibition of beards all around or hair for that matter, all around. And there were some instances where the same concerns that the prison sought to address, hiding contraband, could be used by prisoners putting contraband in their head hair instead of their beards. The court found particularly ridiculous the prison's contention that a prisoner could put some sort of contraband in half an inch of a beard. You know, is the prisoner afraid that they're going to hide guns or something in their half-inch of beard, or forks or knives? It'd be pretty noticeable. So the court was particularly unpersuaded by that argument. Second, about the prison concern regarding changing of appearance. The court said that the prison, if it was concerned about this, about prisoners shaving beards and growing beards and making it difficult for them to track, a solution to that would be take a photo of the inmate when the inmate's admitted, and again once the beard reaches half an inch. That is another means in which the burden on religious exercise wouldn't be so severe. The Supreme Court in 2014 decided Burwell versus Hobby Lobby, and an important point in that case is that although it dealt with the Religious Freedom Restoration Act, this language, the government may need to expend additional funds to accommodate citizens' religious beliefs. We haven't really seen that so far in land use. However, I think it is going to be used by plaintiffs increasingly. There was one case in the Ninth Circuit where there was a soup kitchen that was operating, and residents raised concerns about health and safety in the zone. And in response to that, the religious group said, instead of denying our application, increase the police presence there, even though it might cost you a little bit more money to do so. So I think that is how we might see that come into play some more. And with that, I am going to turn it now over to Dan to talk about another important provision, the equal terms provision.
Sure. So we spent a lot of time on substantial burden because that's really going to be the heart of most of your claims when you litigate these matters. And as you can probably tell from what the three of us talked about, most of these are fact-intensive claims. And on the religious side, we have to show substantial burden, and on your side, you have to show compelling governmental interest and least restrictive means. Equal terms is another important provision of RLUIPA. It's probably the second most litigated type claim. And so the equal terms provision is set forth on your slide on here, page 27. There's really two, let's go to the next slide. There's really two types of ways of litigating equal terms claims. There's facial claims and as-applied challenges. So what's a facial claim? That is a claim where the zoning ordinance itself gives rise to an unequal treatment between religious uses and secular uses. Now it's important to note that under equal terms, it's just religious versus non-religious. There's another provision of RLUIPA that we'll talk about below where you have religious versus religious. But this is a situation, for example, in your zoning code that provides for theaters or provides for auditoriums, social halls like Elks Clubs, funeral homes, parks, city halls, things like that, but doesn't allow for a religious use. That would give rise to a facial challenge. Just one caveat in there is if you have a zoning code that doesn't allow for religious uses as of right, but allows for them as a conditional use, and then has the secular uses as of right, you're going to have to go court by court on those because the case law is kind of all over the place on a facial challenge on the conditional use side. But when it's clearly this is an approved use and churches are not an approved use, you've got a good facial challenge. What's good also to note about facial challenges is that you don't have to exhaust remedies or you don't have to go through the ripeness analysis when the code itself is defective. So you don't have to go through the whole application process as a religious entity. If your code's bad, it's bad. There's nothing really that you have to worry about. An as-applied challenge is when you're comparing a religious assembly to a secular assembly use. So, for example, like I had a case in Jacksonville Beach, Florida. There, in the particular zoning district, it allowed for schools, but it didn't allow for churches. And the schools had auditoriums, it had theaters, it had lunchrooms, libraries, parks, whole 9 yards, all the other places for assembly, for teaching. It even allowed for after-school worship for some after-school groups. But the zoning district did not permit any type of churches. That's when the court there found as an as-applied challenge that they have an equal terms violation. Go to the next slide. So there's really 4 separate equal terms tests. Again, Congress set forth the equal terms provision, but didn't necessarily define it such a substantial burden. And that's great for us lawyers and for planners as well. It's just important to know that depending what jurisdiction you're in, what circuit you're in, what state you're in, sometimes under state law, like in Michigan, it's interpreted differently than the federal circuit. You have to understand what equal terms test apply. You have the Lighthouse evangelism case, out of the Third Circuit, which talks about the regulatory purpose. You have the Midrash decision, which was the first slide. That's the 11th Circuit. That's probably the most cited, and that was one of the original ones. Next slide. You've got the Village of Hazel Crest, which is the 7th Circuit test, which is the accepted zoning criteria test. And then the next slide. Then you have the 5th Circuit, Opulent Life. Each one of these tests really does go for and tells you what the court is thinking in terms of how to analyze these matters. In the 6th Circuit, which is kind of interesting, there's a case called Tree of Life that was just decided, and we have gone through, and in that case, the 6th Circuit said, we're not going to identify what test we're going to use here, but in this one, go back and we're going to make a decision based on some criteria. And they did the same thing on the substantial burden test. So, and the important thing to take away out of the equal terms analysis is make sure you look wherever you're located, whatever jurisdiction you're in, look and see where you're at so you can you know what test to apply, and perhaps one day the Supreme Court will take one of these cases up and make a determination as to what test applies universally. So, next one.
This is Evan. Now we're going to spend about a minute on the non-discrimination provision. This is the 3rd of the 4 provisions under the Religious Land Use and Institutionalized Persons Act. There's not really much case law on this provision of the statute. There is the language of the statute: no government shall impose or implement a land use regulation that discriminates on the basis of religion or religious denomination. It wasn't clear really until the 2nd Circuit's decision in Chabad-Lubavitch in 2014 about what this type of claim even included. Was it kind of like an equal terms claim except for religious groups, whereas an equal terms claim compared a religious application to a secular application? Did this one instead compare religious groups to other religious groups? For instance, a church is approved and a synagogue is not approved. Could that give rise to a violation? The 2nd Circuit said what's really required for this is akin to equal protection case law. And what you need to show here is discriminatory intent on the basis of religion, which can be either direct or circumstantial. And here's a list of different considerations, one of which I want to highlight, the language in red: statements by community members. This is very important for planners and city attorneys and agency officials to know about. Comments by members of the public during the public comment session of a public hearing, or even postings online, on blogs, on comment sections to newspaper articles about controversial zoning applications. Those can all be used to support this type of claim, and it seems a bit unfair, but it's really something that I think is going to needs to be developed a little bit more by the courts. What are the limits of it? And I think we are going to see that in the very near future. Now I believe, Noel, you're going to talk about exclusions and limits.
Yeah, so make sure you're planning for religious uses, assembly uses, if you want to have a content-neutral way of regulating uses. Some municipalities don't have any place for religious land uses at all. So when I take a look at a comprehensive plan or a zoning code and I see that there's no place for a church to go, that's where you're going to say, okay, well, you've totally excluded religious assemblies and I'll file suit under this section. Or if you've unreasonably limited them, which I would take to mean that if it's your regulation of where they can go and how they can get there are unreasonable. For instance, in my opinion, if you don't have anywhere where a religious group can go as of right, as a permitted use, I believe that's an unreasonable limitation. The courts are, we haven't seen a lot of those claims, but that's that provision. So we can move on to the next slide.
And I just wanted to take a minute to talk about this slide. U.S. DOJ enforcement. The statute specifically states that the United States Department of Justice can bring actions under the statute, seeking injunctive or declaratory relief if they believe that there have been violations. A lot of times the DOJ will send letters to municipalities to let them know that they are investigating a zoning controversy involving a religious. Sometimes they'll file their own lawsuits. Recently we saw them file a lawsuit 2 years after the religious group actually filed the lawsuit, which is a little strange, but something that we might expect more going forward. And finally, the DOJ, if there's ever a challenge to the constitutionality of the statute, the DOJ usually intervenes in that case and argues that the statute is constitutional and should be upheld. So here we're going to now move on to some tips for avoiding and defending against these types of claims.
Right, and this is really key to avoiding these claims, and it's training. Doesn't take much out of the budget to hire Noel, Evan, or myself to come out and train, or have somebody train your planning staff, planning commissioners, zoning board of appeals members, or board of adjustment members, or your city council prior to making a decision on these matters. The key again is not to learn how to deny a use, but how to evaluate the use to spot issues and determine whether or not you're complying with RLUIPA. A lot of times when the DOJ, for example, gets involved in cases, what they're going to require in a consent order or consent judgment is that training will be given to all staff members, from city manager to electeds to planning staff and planning commissions and whatnot. So you're doing the right thing today by listening and getting the training. It's so important to before you have something coming up on your agendas to get your planning staff, planning commission, board of adjustment, city council, etc. Give them training on the knowledge of RLUIPA so that they can have a fair and equitable treatment on that matter.
And it's inevitable that either maybe some mistakes will be made, or a religious applicant will just want to litigate. It's important to know that the statute has what's known as a safe harbor provision. The text of it is on this slide. I want to focus in on the language at the end. So the beginning says the government can avoid the preemptive force of the chapter of the statute, go all the way down to the end, by any other means that eliminates the substantial burden. This is extremely broad. It's basically saying that municipalities can take any action that they feel necessary to remediate any violation of the statute. And this hasn't been at least been reviewed by courts very much. most notably, the situation arises in an equal terms situation where a religious group says that excluding religious uses from a zone but allowing assembly halls, etc., is discriminatory. This provision has seen some municipalities take action by removing assembly halls from that zone and saying, hey, now we're treating everyone equally. On the next slide, there's a case, the Seventh Circuit case, that says the statute applies to all provisions of RLUIPA, not just the substantial burden provision. Here are a couple cases for you to take a look at that involve the equal terms provision of the statute, but it's important to know that you can be creative under the safe harbor provision. It allows municipalities to take any action necessary, whether that's by vacating a decision, reconsidering an approval of conditions to either alleviate or amend conditions of approval that are alleged to substantially burden religious exercise. It really gives municipalities authority to avoid liability.
There's one thing, though, you might want to consider, just real briefly. The Jacksonville case, that was mine. Yeah, they did the safe harbor, but they did it 36 hours before trial. So on the second day of trial, they announced that the city council passed this zoning ordinance to fix an equal terms facial claim. The judge was not happy. He agreed that that issue was fixed, but if there was a tipping point in that trial, I would say that was it. So, acknowledge and recognize that you have the safe harbor, but don't do it in a way waiting, several years and doing it during trial, because it's not going to end well for you.
That's an excellent point. And here are some more tips for avoiding RLUIPA claims. Noel, do you want to talk about planning for religious uses for just half a minute?
Yeah, real quick. One of the things that is a problem with a lot of municipalities that have old codes is you're going to have a lot of equal terms violations just written in. You've got codes that just talk about churches, and just because perhaps that's the municipality, that's all they knew in terms of religious assembly uses in the 70s. But more and more we're seeing diverse religious uses, and I'm encouraging municipalities to just go to content neutral zoning of assembly uses, period. And I wouldn't use a one-size-fits-all. I would have, if you can avoid using religious terms altogether and just say these are where not-for-profit assembly uses can go, then do that, because then you're going to avoid a lot of the equal terms problems. Be a critic, look at your permitted use table, see if there's any problems with what we've gone over. Go through this, make sure you've got places where assembly uses, not-for-profit assembly uses can go as of right. You're going to save yourself a lot of headaches down the road.
And related to that, conduct annual inventories of your jurisdictions to see how much land is dedicated to religious use. Is there open space available for religious groups to locate? Designating more space for religious use could help to avoid unreasonable limits and total exclusion claims, and also could provide alternative properties where that could be used to defend against a religious group's substantial burden claim. When if it says there's no other place you can go, you could say, the municipality could say, hey, there's 5 other properties that it can now go to or at least explore. So next slide. Dan, do you want to talk about discriminatory comments?
Right. I guess, just real briefly, on this particular issue, it's very important to avoid those discriminatory comments. There is a really clever case where an attorney that knew he would have an issue going into site plan approval had a community meeting and wanted to hear from the residents about what they thought about this particular land use. And he recorded it, and that, even though that was not in the context of a planning commission meeting or whole 9 yards, those comments were used as the basis for a RLUIPA claim, and ultimately did very, very well with those matters. So it's very important, that the chair control the crowd as best they can, and before something even comes out of their mouth, say we're only talking about the land use issues here. This is the only thing, and just so you can control those particular comments.
That's a very good point. And just to allow enough time, a couple minutes for questions, I'm going to move on to the last couple of slides we have, one of which is Dan has written a great book published by the American Bar Association about how to litigate these types of cases, and it really should be taken a look at by any municipal official out there to know what to expect and how to, even though it is written from a plaintiff's perspective, it's very important to know what the plaintiff is thinking, the religious applicant, and how to work with the religious applicant. And Dan, you have a second edition coming out too.
I do. This one's fair and balanced. It's just like Fox News, so I took it from both sides, the community side and that. It was supposed to come out yesterday. I don't know when it'll come out, but it'll be coming out soon. First edition is available on Amazon. Second edition will be available for about a year on the American Bar Association's bookstore, and then it'll go on Amazon. So really any day now you can look for that.
And the last thing before we take questions is I'm one of the contributing authors to a blog. Here's the web address at the top, www.RLUIPA-defense.com. We provide updates on cases that come out, any news about religious land use applications. You can see we have a page that says cases on it. You can click there, and we have hundreds of cases right there for you to click on. We have resources where you can go and take a look at the latest articles written by Dan and Noel, and really learn some more about this statute. So with that, Ben, I think if there are any questions out there, we are happy to take them.
Thanks a lot, Evan. And this is what we would characterize as a content-rich presentation. There's an awful lot packed in here. And I just want to remind the participants in this webinar that the PowerPoint will be available on the ohioplanning.org website, and the recording will be on YouTube shortly. We do have a number of questions in just a few minutes left in order to take them. So what I'll do is I'll compile the questions and send them to you, Evan, and to Noel and to Dan, and you can answer them if we don't get to them in time now.
Sure.
I have a couple of thoughts. As you were going through the presentations, and Evan, you talked about the non-discriminatory provision and the or actually the safe harbor provision in the language, any other means that eliminates the substantial burden. How does that fit with state enabling statutes that limit how municipalities can act on land use decisions?
That's an interesting question, and one that hasn't been considered by the courts, but I think when you're taking into consideration First Amendment protections, it's a whole different ballgame. And I think that you should not turn a blind eye to your enabling legislation. However, you're not dealing with state law here. You're dealing with federal law. And you have to make sure that you are complying with this federal law. You can kind of think of it as a federal zoning law in some ways, and I think, who knows if it'll be litigated at some point in the future. It's definitely something that should be. I haven't actually thought of it before, but it is an interesting question. But I think a short answer is that you're not necessarily limited by enabling legislation. Dan and Noel, did you have any other thoughts on that?
No, not really. I think you covered it from my perspective.
Yep.
Okay, we have a question from Gordon. This regards IRS qualifications, and he's citing a specific example, which I'll summarize, that involved an appeal process and site plan approval and IRS recognition of the conversion of a nonprofit to a religious organization. And so his question is the IRS status of an organization still a good test to determine if an organization should be considered a religious organization?
This is Evan. I would say it's not a good test. I know some zoning codes out there specifically define religious uses in certain ways, but I think it's important to remember that to avoid violating the Establishment Clause, which is the First Amendment to the U.S. Constitution, municipalities can't say what is and what is not religion. You can't define religious exercise. So it is helpful if to know that there is that designation out there, that IRS designation. However, I think there are plenty of examples where home Bible studies or something like that is also protected by the statute.
Okay, it's now 2:30, so I want to wind up with this, and as I said, I'll pass on the participants' questions to our three speakers. This is a question from Lakey, and I think you alluded to it, but I want you to wind up with this. Please share opinions on whether RLUIPA case, whether an RLUIPA case will make it to the Supreme Court. If so, any ideas when and what case will make it?
This is Dan. I think there's two things that kind of will concern me, and I guess one is that we have a 4-4 split in the court right now, and it seems like there's a pullback on religious liberty. Justice Alito elaborated on that in a recent matter where the court denied leave to appeal. And I think that we're going to see a little bit of a pullback on those. I think we're going to, it's been pretty well established that RLUIPA is constitutional, but now that if we get another Supreme Court justice that's not necessarily friendly towards, religious liberty, I think people are going to make another run at whether it's constitutional or not. Again, it has been held constitutional on the prisoner side in the Sussman case, but on the land use side, they specifically noted in a footnote, and the Supreme Court noted that they've made no opinion on that particular issue. So that kind of concerns me. I think the other area is on equal terms, where eventually the court's going to have to make a decision because we have a circuit split, on what equal terms is, and more importantly, what it's not. And I think, the court either is waiting for the right case, or I don't think, maybe Tree of Life might be a good one if they decide to go up, because the Sixth Circuit didn't really make a test. They just said, go back kind of thing. But I think those are really the two issues that we're going to see in the relatively near future, and see what the court does. I think it's really going to be dependent on, who's going to be appointed to the Supreme Court and which justices remain the next couple of years.
Okay, and we'll take that as the final word. I want to take a moment to thank our speakers, Evan, Dan, and Noel, for this illuminating presentation. I certainly got a lot out of it. Everyone should remember that they can log their CM credits by logging onto APA website and enter their account, searching by activities by provider. This is the Connecticut chapter that was today's sponsor, and search by the title, Planning for Religious Land Uses in an Age of Religious Diversity and Lawsuits, or search by event number 9105796. Thanks very much for joining us today, and thanks again to our speakers.
Thank you.
Thank you.